Lastly, the day concluded with a rapid-fire debate in two engaging segments. In Debate 1, the role of expert witnesses in arbitration was hotly discussed, while in Debate 2, the effectiveness of emergency arbitration was debated, considering its role in delivering swift relief versus potential issues with enforceability. Mr. Belden Premaraj, an expert in the field, moderated these debates, while debaters Mr. Chang Wei Mun, Mr. Cheng, Mr. Jain, and Mr. G.K. Ganesan presented compelling arguments from their respective positions.
Ladies and gentlemen, please be seated. Thank you. We shall now proceed to our fourth and final session for today, a rapid-fire debate. Without further ado, I'd like to introduce Mr. Belden Premaraj, our moderator for the session. Joining him on stage are fiery debaters, Mr. Chang Wei Mun, Mr. Cheng, Mr. Jain, and Mr. G.K. Ganesan. Mr. Belden, the floor is yours. Thank you.
Thank you. One of the few occasions I get to knock a gravel. We are starting a little bit late. The crowd is lessened. We're heading towards dinner at 7, so we'll try and stick to the real, the language of this debate, which is rapid fire, and truly make it rapid. So let me now lay down some of the ground rules that we're going to be introducing. This session, of course, being rapid fire debate, is intended to be short. It's 30 minutes per debate. There are two topics. First topic is about expert witnesses in arbitration and their effectiveness. And the second topic is the recent emergence of the use of emergency arbitrators and its effectiveness. So each topic is taking 30 minutes. Unfortunately, each debater is going to be only allocated 8 minutes to support his own resolution on the topic at hand, and a further 4 minutes to rebut the opposing debater's resolution and the propositions made. Now, I will be making the time allocation strict as well, because we want to really get on with it. And I will try and sound out each debater when you have just 1 minute left. And I will politely and firmly ask you to stop when their time is up. I'm sorry, not throwing, but I'll hit it. Now, understanding that the topic and the resolutions being debated may not in fact land in favor of one or the other, also considering the intellect that is brought to this table by the distinguished debaters, the rebuttal period can be used by the debaters to make conciliatory arguments, i.e. suggesting that neither their resolutions or the other party's resolution is truly correct and it lands somewhere in the middle. I've read them. I think that's the way it is. So bearing that in mind, I'm not going to try and get your vote on which resolution is the correct one, because I believe there's none that is truly correct when I read it. However, I'm sure all of you all, when you see the debate topic, you would have your own personal impressions before the debate starts. So I'll ask you all by show of hands to tell me how many pre-debate support resolution A or B in that topic. And then I will ask at the end whether any of you all changed your minds after hearing the brilliant arguments. So that's the approach I'm going to take, right? Now, if there is time, I will allow questions on either topic from the audience, but only at the end of both the debates, okay? So let me introduce the first debate topic, not to waste time, and the resolutions presented by each debater. I think you will find them in your booklet, the debate content, but let me just have some introductions, because I'm asked to present some introductions so they don't waste time on what their topic is. Now, the first topic, expert witness. In 1782, Lord Mansfield paved the way for expert opinions to be considered in court litigation, 1782, when he said, in matters of science, the reasoning of men of science can only be answered by men of science. Haha. Now, the common law approach has generally been to use party-appointed experts, whereas historically the civil law approach has been to try always to get a joint expert or tribunal-appointed expert. But even these days, the civil law has already been convinced by the common law, and even in civil law jurisdictions, I see now party-appointed expert. So hence this topic of debate. Party-appointed experts. I will limit it to party-appointed experts because joint experts, I don't think this debate arises. Party-appointed experts, the role of such party-appointed experts as independent advisor to the tribunal or a source of conflict for the tribunal, right? Giving you more headache than you would have otherwise had. So the topic introduces the idea of expert witnesses, how useful they are, but also introduces the idea that they can lead to chaos. As we know, the issue is whether they are gunslingers or not. And there are experts in the audience here, so I'm not suggesting anything. It's just a question of whether it will arise. Now, the resolution under House A is that the House A, which is on my right-hand side, contends that the expert witness, with their expertise and appointment process, enhances the independence and thoroughness of the arbitral tribunal's assessment of specialized subject matter. So he is pro-arbitrator, pro-expert witness. This is going to be proposed by the distinguished and renowned Mr. Chang Wei Mun, who has more than 35 years of experience, former head of the dispute resolution group practice in Raja Darul and Law, and now an independent arbitrator and adjudicator in his own practice, right? And the resolution B, which is on my left-hand side, the gentleman on my left-hand side, he will be contending, the House contends that the expert witnesses are susceptible to providing conflicting opinions due to various factors, including the manner of their appointment. So he is going to suggest that expert witnesses can be problematic to an arbitrator. This will be done by the equally distinguished and renowned Mr. George Cheng, more than 27 years in private legal practice, including being a partner in Singapore law firms, UK law firms, and US-based global law firms. Today, he is the founding owner and managing partner of an independent set of chambers in Singapore, where he maintains his practice as an arbitrator and also a counsel, and also involved in projects directly. Now, before we start the debate, can I have the show of hands of those in the audience who think expert witnesses are ultimately necessary? We must have party-appointed experts. It's necessary. Parties must have a right to appoint the experts. Well, okay. And those that do not believe that party-appointed expert is the right way, perhaps joint expert is the only way, because otherwise party experts tend to take positions for their so-called party. Those who are against it, nobody. Wow, okay. So, one. So, therefore, Glenn, you got a tough job of convincing a few more hands the next round. Okay, so with that, can we start the debate? And I will pass the debate, the resolution for House A to Mr. Chang Wei Mun to make his proposal that we need experts, and looks like most of you all agree with him. 8 minutes.
Thank you. Ladies and gentlemen, the use of party-appointed expert witnesses is not new. We've been using them for well over 100 years, and they've grown in popularity. As time went by, arbitrations became more complex, and they encompass many commercial areas which require very technical issues. Now, as it is now, there are many areas of arbitration where expert witnesses are the norm, they're not the exception. Now, why the gain in popularity? I will venture to give you 3 reasons for this. Now, first of all, like Belden says, they are necessary. You cannot run an arbitration on a very technical issue without the assistance of experts. And the reason why they are necessary is that arbitrators do not know it all. Some may think they know it all, but actually they don't. And in those areas where they don't know very much, they need help, they need assistance. I think one of the better ways to explain the situation is to give an example. Some of you may remember some years back, the bridge, the pedestrian bridge connecting Mid-Valley City and KL Eco-City collapsed. Pictures were plastered all over social media of a mangled bridge across the Klang River. The question to be answered in a case like that is, what caused the collapse? Now, if you are an arbitrator, you really won't know where to start. By the time you're appointed, everything has been cleared up. The person who will know how to start and where to start and what to do are the experts, and they will go in and they will come up with their theories as to why the collapse occurred. And they will play a very important and necessary role to educate the arbitrator so that he can actually make a proper decision. The second point I make is that it lends integrity and credibility to the decision. So you have two independent experts who actually give evidence and advise and help the arbitrator to come to an informed decision. That gives credibility. The integrity part is that when you read the award, you will know that all relevant views have been considered. So these experts now, they are very sophisticated. In the case which I mentioned, there were animated videos, there were models, there were explanations as to, they took opposing views, but explanations were given and opposing arguments were brought up. And all this was canvassed. And if you look at the reasoned decision, it will give it an air of professionalism, and it will look like everything has been considered and the integrity will be there. The third point is to allow the arbitrator to spend more time on issues that he himself is an expert in. I think nowadays, many of you might agree with me that the majority of arbitrators are legally trained. They may have some other qualification, but a lot of them are legally trained. The answer is very simple. In arbitrations, there will be issues of fact, but you cannot run away from the situation where there will always be issues of law. Not only issues of law, there will usually be issues of procedure as well that parties cannot agree upon. And a legally trained person, he's the best person to deal with that. A legally trained person is not the best person to deal with technical disputes. So if you're a lawyer and you're legally trained, and even if you also have an engineering degree, to actually sit down and decide issues on why that bridge collapsed, look at all the tests that have been done, and come up with a decision. I mean, you could give the jurisdiction to the arbitrator to actually do his own research, and he might spend 6 months, read 10 books on bridge design, and come to a conclusion. But isn't it better to bring the expert who wrote those books, who designed 20 bridges, to actually give his views, and then you decide on who is right and who is wrong? Now, the point, I'm not saying that using experts is not problematic. The idea is, I think the system is not perfect, but I don't think it is broken to the extent that it needs to be thrown away. We have situations where parties gather together, let's talk about the problems, and let's see how we can actually fix it. The use of expert witness can also be tailored to specific needs of each case. Now, whether the dispute involves scientific, financial, engineering, or other technical matters, expert witnesses can be chosen based on their relevant expertise. And once they are chosen, they can be really helpful. without the guidance of an expert witness, the tribunal as an arbitrator, I'm an arbitrator. I cannot say I know very much about accounting principles. I cannot say I know very much about extensions of time and how to draw up a critical path. I cannot say I'm good at engineering theory, but I have an analytical mind and I need to be educated. And once I'm educated, I can make a decision, I can come to a conclusion. So, in the final analysis, I think I would propose to the House that, I would propose to the House that expert witnesses are necessary. They lend credibility and integrity to the proceedings. They also free the arbitrator to concentrate on issues that is within his purview. They help to educate the arbitrator and raise issues so that the award, when it is issued, will be a well-reasoned and proper award. Thank you very much.
Call upon Mr. Glenn Cheng now to do his to propose his resolution, which is going to be some task since the audience were always in favor of expert witness. But I have certain views which I will add at the end. But go ahead, Mr. Glenn.
Well, the first. Okay, so the first thing is to be very clear what my motion is. And it does not in any way seek to imply that experts are not necessary in proceedings. I was going to put up my hand to say, yeah, I think experts are a great idea and they're an indispensable part of the system that we operate in resolving the disputes that we do. I could be picky and then a little bit more didactic and say, I like good experts to be involved all the time, bad experts a little less of the time, but no experts at all is not my argument. Now, that's the first point I wanted to distinguish. My motion is simply, the House contends that expert witnesses are susceptible to providing conflicting opinions due to various factors, including the manner of their appointment. Now, the strength in this motion lies in yes answers to two questions. And the first question is there truth in this? And the second question is, does it happen? If your answer is yes to both of these questions, then this motion is not debatable at all. It's a slam dunk. Now, if you want to be kind and take a more tutored, nuanced view towards the motion, you might say the House qualifies that some expert witnesses can be susceptible to providing conflicting opinions due to various factors. And the answer is yes, some do. And some take on a brief in which the result is a conflicting opinion with the previous expert and so on and so forth. And why? Because experts like you and I are susceptible to wanting to make a living. Okay, this is the wellspring of the various factors that this motion refers to without going into particulars, so I've had to guess. Now, the next thing I had to guess about in my motion is what is a conflicting opinion? Now, if we are very simple and we say conflicting denotes different, I defer in my view, and you defer to my, not defer to, but my view is different than yours on a similar subject matter. If we say that's synonymous with conflicting views, then actually that's a good thing, isn't it? It really is the point of an adversarial system. Of course, with the initial differences, the tribunal and the judges in court these days are empowered to, panel experts in joint conferences, to throw them into a hot tub, and to iron out differences, and to arrive in agreements of facts, of expert facts, and perhaps even narrow the areas of differing expert opinion. So is that what it means, conflicting opinion? If that's the case, then again, no argument. Yeah, it's a good thing. Now, but I looked at the narrative that we speakers were given, and actually conflicting opinions has its own context. And what it says here in my brief is, however, an expert to one party may actually be disadvantageous to the other. Yes. A disinterested person's outlook on an issue may be unfavorably skewed due to a multitude of factors, and in the event multiple experts are appointed, conflicting opinions. So it seems to me, this is my task, all right. Now, conflicting opinions is thus framed in the context of there being multiple experts. So where in the situation outside of multi-party arbitrations would you have multiple experts opining on the same subject matter? Now, the following points I'm going to raise are based entirely, they're anecdotal, and necessarily so because of confidentiality reasons, but they are based on my personal experience. And the first example I'm going to give you of where conflicting opinions between multiple experts on the same subject matter may arise is when the client takes a report, looks at it and says, well, it's not strong enough. Mr. Lawyer, go find me a better expert. And I want a stronger opinion. I want something else that deals with a bunch more things that the judicious expert A did not cover. So corrective opinions, or superseding ones, substitute expert opinions are an instance. Now, and this is where you have problems, because the earlier expert report is of course discoverable, and it all lends towards the body of evidence, and how you then choose to supplant or to patch over your expert evidence is telling on your case one way or another. And it's a lawyer's cross-examination dream to start poking holes at this sort of fabric, this sort of strategy. Now, in one case which I did, there was a situation of this report's not strong enough, go get me a better one. And a better report emerged on my desk, in which not only have the quantum figures they have grown remarkably, they've through different sets of reasons, but the expert had taken the extra effort of opining expertly on whether a thing or not constitutes a variation, or whether it constitutes an event of compensable time relief, an event entitling compensable time relief. Now that's not only conflicting with the old expert, that's conflicting with the lawyer's role. And so that's not a good thing. But does it happen? Yes, it happens. It happens in these sorts of situations. It happens because of complicated loyalties. Big corporations that retain a particular individual or a firm on a regular basis, a pet expert, if you like, is one such susceptible category. Another is coaching. Many lawyers are guilty of it. In one other particular instance that I encountered, where I directed for there to be simultaneous first round reports, and then for followed by a responsive round of exchange of responsive expert opinions, based only on the subject matter covered in the first. So this is just to cover any gaps. One expert delivered a responsive expert opinion in which it was the whole thing was an exhibition of hostile research that he had conducted against his opposite number, and to try to discredit him in the second report by saying, these are the papers he has written, he has taken contrary positions, he is in no position to give the expert evidence that he did in the first. Now, it looked like a script for cross-examination, much less an expert report, to which, of course, I accordingly ascribe zero weight to its evidentiary value as a matter of expert evidence. So, does it happen? Yes. And if the answer is true, it does happen, and therefore it's true, to argue the opposite, my learned friend would have to suggest that expert witnesses are not susceptible under any circumstances to providing conflicting opinions due to various factors. And that is a Sisyphean task. I think it's actually a statistical impossibility.
Thank you. So now, bottom or form a conciliatory view. Either way, Waiman on house 4 minutes.
Thank you, Belden. I do not disagree with Glenn. He has made some valid points. There are expert witnesses and there are expert witnesses. I think the important point is to find out how we can actually minimize bias, prejudice, gunslingers. And to me, we have to live with conflicting opinions. That's the arbitrator's job, to find out which one is correct. What we can do as arbitrators is to actually set down the ground rules to minimize the chance of something like this happening. What we can do, and it's getting more common now, is that once the experts are identified, even before they prepare the report, call them in. Experts, parties, as well as a counsel. And there you lay down the ground rules. This is how we're going to do it. This is a must if the parties come from different jurisdictions. So if you have an American party, you have to tell them from the outset, we're not doing it the American way. If you've got a French party, we're not doing it the French way. You answer to me, not to your client. You do not take your opinion, a draft, and send it to the party who appointed you and say, are you okay with this? Do you want to make any amendments? Right. When there's a meeting of experts to see whether you can agree or to come up with a draft of the points you can agree upon and what you disagree upon, I will say, in that room, that is reserved for only the expert. Parties are not allowed, counsel are not allowed. And again, when you draft out the agreed points, don't send it to anybody for approval. If you make the mistake, later on you can explain it to me. During that meeting, you can't say it in so many words, but you can give the experts the impression that the tribunal has enough salt to be able to tell whether you are biased or not, whether you are being independent or not. In other words, you're sending them a silent message that I've got my eye on you, right? And if I make certain directions, you have to comply with them irrespective of what the parties say or the lawyers say, because I have the power of the whistle. I blow that whistle, there's a foul. You better hope I don't issue a penalty, right? So I think there are the other issues that I grapple with, experts who are qualified or not qualified. I would rather deal with it at the outset. So at that meeting, you could actually say, look, you have any problem, yeah, to be raised about the experts. So I think at the end of the day, I think experts are necessary. There are problems, but I believe they can be dealt with. Thank you very much.
Thank you, Waiman. Now, Glenn, you have 4 minutes to rebut or conciliatory statements.
Okay. No, very little to rebut. I'm actually in tacit agreement with a great deal of what House A propounds, except to say that for various and many reasons, but not entirely based on the reasons they set out in their motion, Now, the motion at House A says the expert is a good thing because expertise, knowledgeable expertise, enhances an arbitrator's independence. Now, I think that's a misnomer. Now, an arbitrator's independence is a measure of his disconnectedness to the parties. Okay, whether be it on familial, relational, historical, and I suppose even ethical grounds. So an independent arbitrator and the quality of his independence, I would contend strongly that has nothing to do with the quality of the expert before him. Now, the other limb which House A's motion turns on is to say, well, all right, expert evidence is a good thing because it teaches the arbitrator well, and therefore it guides his hand to produce a more comprehensive understanding of the. Yeah, that part is true, but let's not forget it can be rubbish in, rubbish out. If you have an expert report or opinion that is tainted for the problems that I have raised earlier, that isn't helping the arbitrator at all. So I think these are not really considered outlying arguments, but they are central to the very core that goes into what House A is arguing, and I think perhaps we need to come back to the exact wording of what's in the motion of House A and to ask ourselves, well, has that case been made? And I would say, not being unconciliatory, but I think the answer is no. We don't agree over here at House B that expertise has anything to do with enhancing an arbitrator's independence at all. And if you look at the other other good virtue of arbitratorship being impartiality, again, there's nothing to do with the quality of expert evidence. They're really separate things, and so I think we have to be careful how we give the vote, if we're considering at all, to House A, just because I don't think the case has been made. Thank you.
Thank you. Now, as a summary, it's quite clear that both debaters took the approach that I think what the audience do agree, who can do without expert evidence, right? Because you can't get an arbitrator who is an expert on all matters, jack of all trades, but then he'll be a master of none. So that's the truth. Expert evidence is required. However, there's always a but. And the but comes out from the fact that, as Glenn has said, there are many cases, we all know, of experts acting, unfortunately, as an advocate for their client. Some of these cases have gone to the court, some very renowned experts in England. I think because it's a court decision, it can be, I can name it because it's already public knowledge, Pickavans, such a great man of such great stature, such great books, but totally discredited in court cases all the way up to the Supreme Court because of arguing his client's case rather than being an independent expert, unfortunately for him. So there are these situations. So Weinmann's answer is tribunal take control of the experts, right? Remind them that their duty is to the tribunal and not to the parties. Control the system. But there is one other element here that is not being considered, I believe. It's the technical difficulty when you have conflicting decisions for an arbitrator who is not technically knowledge to decide which expert is right and wrong. Let's take programming, and for all those in the construction industry, programming is one heck of a nightmare. EOT. Different methods of assessing EOT is used by different experts, coming up with completely different results. And then a debate over which method ought to have been used is then surfacing. As Jain mentioned, he had an experience in Dubai where it took 6 months to argue over which method to be used in an arbitration before you get into what the experts' findings. Now, my experience, and I'm not suggesting no expert, I gave a big hint that are there areas of expertise evidence where parties can draft into the arbitration clause that it be done by a joint independent appointed expert. So you experts out there still got a job, but not two, one. right? And then that report is brought forward to the tribunal. There can be still arguments that certain facts were not considered, but at least you don't have this big problem of two different methodologies used, coming up with two different outcomes, where the Mr. Arbitrator, who's not technically trained, now is going to make a decision on who he prefers, not on the technical itself. So there is elements of which we need to really consider the potential of introducing joint party appointed experts or tribunal appointed experts. Not to say we don't have experts, but that process is my view. So has anybody here who thought experts are required are willing to support the idea of a joint expert being used in very technical matters and draft it into the clause to reduce the disputes and reduce the issues in the arbitration? Are you all in support of that? Hands up. Okay, so some of y'all. So it looks like that's, as I mentioned, this issue lands in the middle. Neither is House A right or wrong, and neither is House B right or wrong. Both have their points, and we need to find a middle part on this. So with that, I end the first debate. There's no winners and losers with this, as I've said. I think the middle part is what we need to look for. Now we go to debate 2, and time is running. Now, let me introduce debate 2, the topic and the resolutions presented. Now, there are probably some of y'all out there in the audience that don't have full knowledge of what emergency arbitrations are about. So let me just introduce that concept, because I don't want the debaters to waste their time over introducing that concept. Now, emergency arbitration and emergency arbitrators and emergency arbitration proceedings is a procedure that allows a party to request in an institutional arbitration, it only applies in institutional arbitrations, for the institution administrating that arbitration to appoint initially, before the tribunal is actually appointed or constituted, appoint an initial independent emergency arbitrator to determine matters of urgent interim measures, such as injunctions, on-demand bonds, intellectual property expropriating, dissipation of assets, preservation of the subject matter of the arbitration, all those kind of interim measures to get an emergency arbitrator to deal with it. Now, an emergency arbitrator will in all cases be appointed before the actual tribunal is constituted, because if you have the tribunal, you don't need an emergency arbitrator. It's brought in because they find that a lot of times the constituting of a tribunal, especially a 3-man panel, takes time. It takes 1 month sometimes or 2 months, right? So the emergency arbitrator will then hold an emergency arbitration proceeding within the parameters that are set out in the institutional rules on emergency arbitration, and then will deliver something called an emergency award. It is usually never ex parte, so there's not going to be an ex parte here. It's always inter partes. Usually when the tribunal is then later on constituted, that tribunal may reconsider, modify, and set aside that emergency award. And the arbitral tribunal is never bound by the reasoning of that emergency arbitrator. But at least it gives a starting point for a party that needs something urgent to get it done. AIAC introduced the rules for this in their 2021 rules, but this is not a new concept. This has been around since 2006 with the ICDR having it. ICC introduced it in 2012, SICC introduced it in 2013, LCIA introduced it in 2014. So it's been around for some time. So the debate now is emergency arbitration, swift relief, or questionable effectiveness. So the question here is it really useful? Will it really give relief? Or is its effectiveness in question? That means it doesn't really work. Okay, so resolution House A. On my right-hand side, House contends that an emergency arbitration is an effective and immediate solution for parties seeking interim relief, providing valuable remedies in urgent situations. This resolution is being supported by the distinguished and renowned Mr. Jain. He's a senior partner at Regis Legal LLP and is a member of the Bar Council of the Maharashtra and Goa courts. He also worked as an independent counsel at the Bombay High Court. He's associated with a few of India's topmost leading law firms at the beginning of his career. He's an independent arbitrator and paneled as an arbitrator by the Bombay High Court. He's presently paneled in more than 26 jurisdictions, including Malaysia, and he has more than 20 years experience in his area of practice. The opposing resolution, I won't say opposing, the other resolution, House B, contends that the emergency arbitration is actually an inadequate means of delivering proper interim relief in arbitration proceedings due to the potential issue of an emergency arbitrator not being able to appreciate the facts and issues, and also the question of enforceability of the emergency award. Can it be enforced? This will be supported by the equally distinguished and renowned Mr. G.K. Ganesan, which all of us in Malaysia know him very well, comes with qualifications not only in law but nuclear science, fellow of a number of institutions, empaneled as an arbitrator in a number of institutions, more than 30 years of experience in the area of practice, and a fervent writer of many articles and blogs. One of his fabulous blogs called GK Legal, if you go and read, he has intellectual thoughts on a variety of subject matters, and I always find it very great reading. So, before we start, to those who understand emergency arbitration and those who may have experienced it, can I have a show of hands for those who think it is effective and it is useful? Show of hands. Okay? I'm not really counting, but there's a few. To those that don't think it is effective. Lesser than those who thought it was effective. Okay, but about equal, so we'll see. So, we will start this debate, and Mr. Jain will start. He's got 8 minutes. He's proposing that it is effective and a real solution. Thank you.
Thank you, Belden. Good morning, everyone. And first of all, I would like to thank...
Sorry, he's got 8 minutes, not 4.
Yeah, I think we're running short on time. So
Sorry, go ahead.
Okay, first of all, I would like to thank the AIAC and Dr. Sundara Rajo for inviting me for the event. Obviously, I pay my respects to all the dignitaries who were present since morning. It's been an enriching day for us on the topic of arbitration. And thank you, Belden, for introducing the concept of emergency arbitrators to all of us. Now, just reiterating what you said about the emergency arbitrator being distinguished than the tribunal, keeping that background in mind, I just wanted to preface my argument by showing why a person would select emergency arbitrators. And the reason is not very different than why you would choose to go for arbitration in the first place. And there are 3 reasons. One is time, second is the procedural flexibility, and third is the confidentiality. These are the 3 reasons why an emergency arbitrator is chosen in the first place. As Belden was mentioning, when a tribunal is required to be constituted, there are ordinarily 4 stages, in practical terms if you take it, which are involved. First is the party invoking it. They have to send a notice to the institution. The institution, the copy of that invocation is also marked to the respondent. The second step is the respondent suggesting a different name of the arbitrator. We've seldom seen that, there are common arbitrators selected. It normally, the third stage falls upon the institution to select the arbitrator. And then the 4th stage is that the tribunal is constituted, and then you are able to move for an injunctive relief or for an emergency relief. And this process normally takes about anywhere between 30 to about 45 days. Now, the essence of choosing arbitration was time is the essence. If the time is lost, what's the point of an injunctive relief? And that's where your emergency arbitration kicks in, to save that time. Because in all emergency arbitration proceedings, the time is kept to the minimum. For instance, the SIAC provides that the appointment is to be done by the president of the SIAC within 1 day of receiving the notice invoking emergency arbitration. And the emergency arbitrator is required to decide the entire relief within 14 days. So time is something which distinguishes of why an emergency arbitrator is required, why it is effective. Because even if you get a relief from the tribunal after 30 days, after 45 days, the effectiveness of that relief is lost if you're dealing with situations where the goods are perishable, or whether the assets are going to be sold off, or the shares are going to be sold. So these are reliefs where time becomes of the absolute essence. Now, normally one would argue that this reliefs can be granted by the court, but that's where your second pillar stone of arbitration kicks in, and that is confidentiality. The reason why you chose arbitration in the first place was to keep the dispute confidential, to keep its contents confidential. When you choose to go to the courts for an emergency relief, you're putting out everything in the open before the court. That is not what happens in an emergency arbitration. And the third is procedural flexibility. Now, when you go before an emergency arbitrator, whether it is effective or not can be decided simply by the threshold that the emergency arbitrator needs to meet. Sorry, the parties before the emergency arbitrator needs to meet. And that threshold is whether the emergency relief that is sought by the party can wait till the tribunal is constituted or not. If that threshold is met, the arbitrator has the complete flexibility to determine within how much period the response is required, whether the submissions are required to be recorded through a live transcript, or whether a written submission is required, whether to hold the meeting virtually or whether to hold it in person. These are normal procedural flexibilities which ordinarily the courts would not be able to provide. And I think that these three things are what puts the emergency arbitration on a different war footing altogether, because these are the three things that the courts would ordinarily not be able to provide to the parties in an arbitration. And I think what Belden said is the defect that is there, that the arbitrator has been given a very short time to prepare, can be cured by the tribunal that is subsequently appointed, because once an emergency arbitrator passes the protective relief, it is always open for the for the tribunal constituted to revisit that. It does not require any change of circumstances. It does not require for any fresh application to be made. It requires that the tribunal finds it justified that the reliefs that were granted were not required to be done at that stage, or are not required in the facts of the case as it is now laid down before the tribunal. So I think in that sense, the real defect in the emergency arbitrator's decision being made very quickly is really not there. And the second point which Belden specified was with respect to the enforcement. Now, I don't know how many of you were there in the morning when Justice Arjun Sikri was mentioning there was an emergency arbitration award which was passed by SIAC recently in the Amazon versus Future Retail case. And India is considered normally a jurisdiction which is taking 2 steps forward and 1 step backward in arbitration. But given that the Supreme Court of India had upheld the emergency arbitration award which was passed by SIAC. So, even a jurisdiction as, not to say conservative, but more neutral, like India, has also given the enforcement to an arbitration award which is held in a different jurisdiction altogether. And I mean, time is a constraint, so all I'm going to say is that an emergency arbitration is effective on multiple footings, and I hope you vote for that. Thank you.
Thank you, Ish. Now I'll pass the floor down to my good friend G.K. Ganesan, who will be suggesting that it is not effective because it's got these problems as set out earlier. 8 minutes.
My answer to this is that one size shoe doesn't fit all your feet. A relief is only as good as the problem. If you look at what we are debating today, it's about the inadequate means, the emergency arbitration interim relief being inadequate means of delivering a result because of two problems. An arbitrator's inability to appreciate the facts. That's what the motion says, and I'm limited to that. And secondly, enforceability issues. What I thought I would do would be to summarize for you the 5 points I'm about to make. Number one, there is a danger of an interim award becoming final. Number two, there is a lack of a proper evidentiary hearing even in an interim application. All of you have gone to court, you know what it is to get an injunction or a Mareva order, how much facts are put across, how much it influences the judge. The third one is a relation to the second. It's rushed decision. It's too short a time. And the fourth one is, what happens if you get an award like that? Is it enforceable? What about jurisdictional issues? And the fourth one, is this decision binding on the later appointed tribunal, which will actually try the substantive dispute? So an emergency arbitrator is always appointed before the actual tribunal is appointed. You got to remember this. So the next point I want to deal with is to show you some trends of decisions. And I'll take you to the Stockholm Chamber of Commerce, and what it did was, it did an analysis of emergency arbitration decisions from the year 2010 to 2013. I'll give you an example of case one. There's too much material there, and I'm very short of time. There, what happened was, in Stockholm, you cannot ask for an ex parte order in an emergency arbitration. What the applicant wanted was, he wanted a restraining injunction with 2 points. Number one, the respondent was restrained from disposing assets. Number two, state authorities from restrained from registering any land transactions. What was the decision? The emergency arbitrator dismissed it. And the third point is the most important point. If you are a party to an agreement with another private party, your rights don't take priority over third-party claims because you are involving a state. The next point I wanted to make was in relation to becoming an interim award becoming a final award. This was another Stockholm case number 2. It happened in the year 2010. What there happened was, they went to the emergency arbitrator and said, excuse me, can you now make a finding? If you find that the termination of the agreement was unlawful, then what I want you to do is, the respondent must deliver to me all these products that I will now list, and you must give me access to all the tools for services and maintenance work, whether or not the agreement has been properly terminated. What was the decision? It was dismissed. Why? Because the arbitrator said that the relief sought was final relief. The order for delivery may take the later award, make the later award superfluous. Now, it may obstruct business. The arbitrator refused to rule on the substantive issues because he said that would be a matter for the tribunal. Next, we go to the point about rushed preparation. This was another case in Stockholm in the year 2010. There was a shareholders agreement which had been breached. The relief sought was the respondent cannot dispose of his shares to anybody or assign it. The decision was allowed, but the respondent didn't have enough time to show, because he had only 14 days, he didn't have enough time to show why the claimant was wrong. And the takeaway from this case is, if you have difficulties marshalling facts at an emergency arbitration, you are done for. The next point is unenforceability. The UNCITRAL explanatory note is, emergency arbitration awards are binding but not enforceable, and they say, look at this particular here it says, preliminary order has a maximum duration of 20 days. While binding on the parties, it's not subject to court enforcement and doesn't constitute an award, and it has limitations. So that's on the enforceability point of view. The next one is, it has got a very limited binding effect as opposed to enforceability, there are 5 points. I'll take you to the 5th point straight away. The arbitral tribunal is not bound by decisions or reasons of emergency arbitration. Now, I want to take you to the next consideration of, is it rushed? SEC, Article 8, 5 days for the arbitrator to make a decision. AIAC, for 15 days. LCIA rules, 14 days. SIAC rules, 14 days. Delhi International ARB rules, 14 days. What can you do in 14 days? You file an affidavit. He files an affidavit. He files an opinion. You write an opinion. He writes an argument. He writes a counter argument. Everybody will be writing 700 pages. Is it going to be effective? Now, let me take you back to another case about enforceability issues. There was a case called Vital Pharmaceuticals. It was sued by PepsiCo. PepsiCo said, can you please stop interfering with my exclusive distribution rights until the arbitrators panel convenes and could decide on the case? And they said, yeah, fine. Then they allowed the injunction. And you know what the district court said? It said the exclusive distribution rights, I now make a ruling, is binding, and that decision ended up in the county court, and the court said you cannot appeal against it. So can you see this? And a purely 20-day rule has now become perpetual. The next point is a case called the Al Raha Group, which I think everybody is familiar with. In 2020, what happened was they refused to affirm or enforce an emergency interim award under the American ICDR rules. The reason was because the emergency award made by the arbitrator wasn't an interlocutory award, it was a final award, and they lacked the subject matter jurisdiction. And guess what? The parties waited for 1 year for the court to make its point. So we are back to square one. Therefore, let me tell you straight away, with 50 seconds to spare. Injunctions are good. Preliminary orders are good. But they are good only for some purposes and for some disputes. You can't take a Panadol and give it as a medicine for cancer. You cannot take an injunction for painkillers and give it for somebody who's got a colon cancer. Every remedy must be fitted to its illness that it purports to serve. Those, my dear friends, are my arguments. Thank you.
Thank you, GK, for the colorful debate. And now, Ish, you've got your hands full.
Yeah.
4 minutes to
Yeah.
rebut or to agree on some points.
Well, I'll tell you what I agree on and what I don't agree on. The first aspect which GK mentioned, one size does not fit all, absolutely agreed. There cannot be two ways about it. And the idea whether an emergency arbitration is effective or not relies on a presumption that when a person is seeking emergency arbitration, it is because it is required by that party. And if it is not required, it should not be the insistence by the attorneys or by the counsel to ask for an emergency relief when it does not fit. But the question is, once it does fit that it requires an emergency relief, what then? Whether there is a finality, I believe that an emergency arbitrator's ruling does not attain finality because it is open for the courts, it is open for the subsequent tribunal to decide that issue again. Now, practically, I'm sure all the arbitration practitioners over here would agree with me that if a ruling is given by the court for an emergency relief and then subsequently the tribunal is constituted, there is very less likelihood that the tribunal would revisit that order and change what a court is held. As opposed to this, when an emergency arbitrator has decided an issue, it does not require any change of circumstances for a party to raise before the constituted tribunal to alter that order and make it or probably re-argue that issue with better preparations. So on terms of finality, I do not agree with my learned friend. Lack of evidentiary value, we are at injunction stage, so obviously there will not be so much of evidentiary value as much. I mean, it is almost identical to how we go to the courts to ask for an injunction. We do not have a situation where we lead evidence before we ask for an injunction. So I would disagree with my learned friend. Rush decision, yes, I agree that there will be a rush decision, but therefore the countermeasure is provided in most of the rules where the subsequent tribunal constituted is allowed to revisit that order. Enforceability, my learned friend pointed out the ancestral rules, which does not allow for the enforceability. The ancestral rule, unfortunately, does not deal with emergency arbitrators at all. And just as Belden was mentioning that the 2021 AIC rules provided for that. But now, because the AIC rule, the one which is launched today, refers back to the ancestral rules, it does not anymore have the emergency arbitration. Okay. Because... all right. Because I just had a glance today. All right. And whether it's binding on the subsequent tribunal, again, something which most of the arbitration rules provide for, that it's not binding on the subsequent tribunal, the tribunal is entitled to change it if it finds it appropriate after considering the evidence, after considering the parties at length. If it finds reason to believe that the emergency arbitration relief was beyond the jurisdiction, beyond the scope, beyond what it was required, then it can alter it. The last point that my learned friend made was with respect to the third-party relief. This is the second point that I agree with him. That third-party reliefs, yes, you can't have an emergency arbitration for third-party reliefs. You will have to go through the courts, or you will have to find another method to get protective reliefs against third party. Just because my learned friend threw a lot of statistics and case laws at me, just to counter that, just finishing that. The SIC had 94 emergency cases till date, and the ICC has 130 emergency arbitration cases till date. I don't have statistics for the other institutions, but these are all cases which have been effective so far, at least.
Okay. Thank you, Ish. GK, your 4 minutes starts now.
I ask this question: why do we need interim relief? Why do we need it? Because we don't want the other party to steal a march on you. Suppose I have shares, and they are international shares. I own a company in the United States. As a shareholder, I'm in Hong Kong, and I'm trying to make a patent in the United States. And what the other side does is, somebody removes my right of shareholding, and I lose my right. What I need to do is to run to the court and to get someone to stop it. It will take me 3 years if I get to court in Malaysia. Okay? Sometimes 4 years, you won't believe it. But if you go to an arbitrator, it takes 14 days. Very good. In a situation like that, it works. So insofar as time is concerned, if time is of the essence, it works. But it depends on the nature of the dispute, on the nature of the subject matter, on the nature of the relief. If I have a problem with you that you have created chemicals that are killing 200,000 over people, if you watch the oxytocin or something, there's a TV network thing going on, my wife showed it to me. If I'm going after you for killing 200,000 people in the US because of the poisonous nature, and there is some kind of arbitral clause, what would an injunction do? People are dying, so it wouldn't be useful. Now, the next one is to understand that the dispute shapes the relief. I think that statement explains itself. The point about time is both useful and useless, depending on what the nature of the issue is. I agree that if the relief fits the problem, it's fine. It should preserve status quo, nobody should steal a march, and whether it amounts to a final relief depends on the nature of the dispute. So if I have an exclusive distributorship agreement with you, and I go and get an emergency order from you, and the court says, no, I'm going to allow you to screw it anyway, and 30 other competitors come and take over all my products that I'm distributing. By the time the arbitration is over in 2 years, I'll be lost 30-40 billion US dollars. So sometimes it may look like final, but the dispute shapes the relief, you see. So the next point is, I think we need emergency arbitrators, and I do think we need emergency relief. But I think we got to be very careful about it. Thank you.
Thank you, GK. So I think I will give my 5 cents worth now. Again, I think everybody is right. GK is right and so is Ish. Now let's look at why emergency arbitration came about and compare that with before. Confidentiality was clearly one issue, but another big issue is the fear of the jurisdiction and going to the court of that jurisdiction. If I need an injunction against a state-owned company and I have to go to the court of that same jurisdiction, I am a foreign company and I won't be too comfortable with that. An emergency arbitrator who's independent gives me more comfort. So those are real issues, and that's part of the game of why arbitration was created, right? So confidentiality is there. Now, urgency, however, I think there is a difference. My examples of injunctions when I need it for an on-demand call on the bond, I don't think an emergency arbitrator is going to help me because the bond will be paid in a day or two. And that one, I need ex parte assistance. So in an ex parte assistance, your emergency arbitrator cannot do it. He's going to take 14 days, 20 days at best to give you, by which time the money has been transferred, and you can't get mandatory orders from an emergency arbitrator, because I do agree with GK, mandatory orders from an emergency arbitrator effectively causes a problem for the tribunal after that, because it's not binding and yet there is already a mandatory order that causes an issue. So, yes, there are some injunctions which only the court can help you. Enforcement, some jurisdictions recognize the enforceability of an emergency award. Malaysia, we have. It can be enforced by a court, so we have that luxury. But again, yes, not all injunctions are suited. So if an international client comes to me and is not comforted by our local courts, fears our local courts, but he wants to injunct an on-demand bond, I'll tell him, you're kidding, right? So we have to go to court. So again, it's about what circumstances. But the fact that an emergency arbitration provision exists is extremely helpful. But more importantly is another issue. Because of the speed, you see in court, you get an ex parte order, people file affidavits, 14 days. By the time the judge hears it, you'll have a full day of hearing and all the evidence, a large number of evidence is out. You don't have that option in the emergency arbitrator situation. So it'll be limited evidence before, but that's where the tribunal's option to revise, modify, or set aside, essentially, annul, is there. And they exist in our rules in AIAC. But so the ultimate question is, what situations fit emergency arbitration? So it works in some situations, and it probably is not effective in other situations. That's the answer, and that's why everything is conciliatory here. So the people who thought it was good, emergency arbitrations, has anybody changed their minds? Show of hands? No? And anybody who thought it was bad, have you changed your mind? It's hard to say because circumstances may require it. The good thing is we have the rules and the options are there. Prior to 2021, we didn't have that option. So thank you, everyone. And I thank the panel, the debaters, the distinguished debaters for giving their views on it. Some of them were forced to argue certain things when they were not totally in for it. And as we saw in the responses, everything was fairly conciliatory. Thank you for your patience. Now, I know we are way past our time, but we started late. Are there any questions on either expert evidence or emergency arbitration? Or are we all too hungry and ready for the 7 p.m. majestic dinner? Yes, please, please. Yes, I can.
So, for emergency relief, we also have a clause that in India we have Section 9. So, to that extent, we don't really need a emergency arbitrator.
Yeah, can you? Yeah.
So did you get my question?
Yes, yes.
Yeah. So it's more of an observation, not a question. So when the courts are there to provide emergency relief, why do we need that?
Okay. I think Ish can
Should
answer
I?
it. It was from India to India.
I mean, that was just an example. Most jurisdictions
Well,
have
yeah,
that.
it's so in Malaysia. So in Malaysia.
Yeah,
That's
yeah,
why you
yeah,
have
yeah,
the
yeah.
option. But your question is, why do you even need emergency arbitration when you arbitrators when you have the option? to
When
run
the
to
Act
court?
itself provides for it.
So I'll give you, the first reason is very obvious. It's confidentiality, as I mentioned, that even if you could go in section 9 before the courts, the fact is confidentiality. Getting copies out of the court is a matter of course for the media, for everybody. So the dispute is out in the open. Majority of the people where international arbitrations are in question, they do not want to wash their dirty laundries in the public areas. So one is confidentiality. Second, I would like to give you an example of one of the cases where so India doesn't have a provision for emergency arbitrations, but it is something that the court determines that an emergency arbitration is required. So
But that could be overturned by the same tomorrow. It's not part of the statute.
yeah, it's not part of the statute. So I'll tell you one case in which I was appointed as an emergency arbitrator under a section 9. So it was before the courts, and the courts decided that we require an emergency arbitration, emergency relief in this particular case. And I was informed by the judge's associate that I need to decide the case within a matter of about 48 hours. And that's because the products that were involved in that was an FMCG. So if I do not decide the issue, or if I do not ensure that the business is running, these are perishable goods, and within a period of 48 to 72 hours, I mean, the goods would be useless. The stock in trade is lost. So, the courts do find a way to enforce the emergency arbitrations in India as well, even if it is under Section 9. Though I would love to have a provision in India for emergency arbitrations, but, the courts are making their way through that. And as I mentioned earlier, India is 2 steps ahead and 1 step behind. So let's hope for the best.
But if you imagine a international party trying to get an injunction against a state-owned, Indian state-owned company, and then saying, we'll go to the state-owned company's jurisdiction, their courts,
Yeah, won't
and think
happen.
the courts
Yeah.
will give us help. So they may trust an emergency arbitrator. That is one of the main reasons why people even have arbitration, because they don't trust court jurisdictions on some areas. And we saw the earlier debate over annulled arbitration awards also can still be enforced in other jurisdictions. It's the fear of court. So the trust is in an independent arbitrator. An emergency arbitrator can still be a foreigner, right? But 48 hours, 72 hours is tough, but sometimes judges have to make that. But to do it inter partes and not ex parte is even tougher. And here in Malaysia, when I'm always very clear, if somebody offers me an appointment, in my diary has got other matters, I have to say no, because this is not a joke. It has to be taken seriously. You've got to get down, do your best you can in such a short period, and flush out as much of the evidence and get the parties to, within 24 hours, to start producing documents for you. So don't take it if you don't have the time. That is my answer to emergency arbitrators as well. But it is a tool that is there to assist international trade, I think. Domestic is a whole different story. Domestic, if you are 2 Indian parties, why don't you trust your own courts? So then you may very well have that justification.
The question is not of trust in India. The question is time.
Time, yeah. Okay.
This
But
overburden of care.
ex partes you can get quickly.
Ex parte, yes. But, so it's a joke right now going on in Bombay, where there are separate fee memos which are charged to the clients for having the matter listed on the board of the judge, because it's a Herculean task now to have the matter listed in the Bombay High Court, because of the dearth of the case that is there. It's just the burden that is there after the COVID period is tremendous.
Getting heard is tough in India.
Getting heard, getting your day in the court is tougher
Okay,
now.
Okay. That used to be the case in Malaysia before we introduced the certificate of urgency and all that. We have a concept now that allows you to be heard within a day or 2. But previously, what we used to do is go outside the judge's room and stand there, and while he's having lunch, walk back, try to ambush him and get him to hear us, because we follow the system like I mean, during my time in practice in the 1990s, it was like that. It was exactly like that. It'll take sometimes long. And secondly, it then becomes a little game in court where you get an ex parte and you drag out the inter partes for 8 months to 10 months, having had the benefit of an interim injunction, which you won't get in the case of arbitration.
Emergency arbitration.
Yeah.
Okay. Thank you. I leave to the other side to counter him.
I have another view. The person who asked the question is from India, I presume. The national dress of Burma is the lungi. So we used to have what was called the sarong injunctions, if you remember. Inter partes. I'll call Belden and say, look, they're going to move on a performance bond on Monday morning. It's now Friday at about 6 p.m. I just found out. What I'll do is I'll give him a call and I'll say, I'm going to see this judge, and I call the registrar, and the registrar will call the judge. He will be sitting in his lungi in the house with his singlet. So I'll be rushing and there'll be a car at the back of me being driven very fast. Definitely defense counsel. You get there and he'll say, first question, undertaking as to damages. First question, undertaking as to damages. Why can't you wait until Monday? They're going to move the performance bond. It's so many $1 billion. It involves a waterway project in Florida. I cannot wait. And the money is from a Malaysian bank. Okay? First, undertaking. Second, I don't want to hear about serious issues to be tried. What are the balance of convenience? You have 3 minutes. Then the other guy is leaping up and down. Nobody has filed any papers. Nobody has filed any writ. Nobody has filed any statement of claim. All oral. He will give you an order on a piece of paper. You have to take your draft order. He will cancel. He will sign it. He'll hand it over to the other side. It led to good results and bad results. Then we became very formal. You want an injunction? You first have to file a statement of claim, a writ. Then you have to support it with a motion. Then you have to file affidavits. You have to do exhibits. Those days, no. You give your undertaking to the judge. You will file all that. It's done. No writ. But because we have become very formal in the courts today in Malaysia, an injunction takes me 3 months. I'm telling you. If somebody comes and tells me, I will give you now $500,000 you get me an injunction, stop the money from being paid out by the bank, I'll tell him you keep your money because I cannot get it. I cannot get it because if I go to court and I'll file it, there'll be 50 other injunctions. I have to get on the list. And everybody says in his certificate of urgency, it's a matter of life and death. My mother-in-law will commit suicide if I don't get the injunction. It's difficult.
I've experienced otherwise, you know, with the certificate of urgency being heard, okay, same day you file, chances are no. But the very next day, some of our courts, our construction court is very effective. And I think they also read what is stated in your certificate of urgency. So bonds, I think they all understand. Money goes, the injunction is worthless already. So the thing is academic. So they tend to, and then you file, they want you to still file a writ, but you don't have to file your statement of claim. You file your writ only with a brief statement, and then you can file your undertaking to file the statement of claim later. Affidavit also, you know, in Malaysia, we always need Bahasa version. That one also, the judges will say, Namai, put your English version, undertake to file the Bahasa version later. So commercial courts have become more effective. But the longi sarong going to the house and knocking the door for an injunction is very dangerous, you know, because that's friendship and everything else involved. So I wouldn't subscribe to that anymore, but there was a time for that. Of course, unless it's something so urgent, like it happened once for me when we had to restrain a plane from taking off. Airbus got a restraining order through an emergency. The flight was going to take off in 3 hours and the plane hadn't been maintained properly. So there was always a danger it could fail and there could be a crash. And the judge heard us at home with a phone call and he granted that because that human life involved. All right? The balance of convenience at the other side is all these people have to be compensated for their ticket and all that, which Airbus was willing to do. You know, so that can happen. But a bond is not that kind of life and death situation. So yes, they will hear you. So I think our courts have become quite effective. You know, but India is still a problem. Huh?
The same concept is there in India of the certificate of urgency, but as GK was mentioning, you know, everybody's mother-in-law is going to die.
yes.
So that's how it is. And obviously there are times when the judges do realize that, you know, for example, bond issues or ship arrest or those kind of cases where the judges do list it on the very same day or on the next day also. but it's still the dearth of case that are there which requires urgency. So there are people, getting a bail application on the board is also taking about 20-25 days, which just shows of how much of amount of work that the judges are asked to do in the short time that they are given.
Sure. So that really explains why emergency arbitration would be useful in India, right? Okay. Any other questions? I hope that I have helped you, given you an answer. With all this debate that we had here, we are all lawyers. One day we argue this side, the next day we argue the other side. But the truth is, this is intellectual, and as I said, everything, it all depends. So GK's point also, it depends. There are needs for emergency arbitrators. Sure, go ahead.
Right. Not wanting to talk out of school, but so I've presided 3 emergency arbitrations, and all of them were seated in Singapore, and 2 out of the 3 of them occurred over the Christmas period in consecutive years. So this was a relationship changer between me and SIAC. But they were interesting, and they did move at a very, very quick rate of knots, and you really had to get your head into it fairly rapidly. One of the things that we talk very liberally, very broadly about bond type cases and how, is it emergency arbitration, that's the best antidote and so on and so forth. The thing to remember is, as an instrument of arbitration, it is confined to the arbitration agreement. And if you have the signatories of an arbitration agreement being the signatories of an underlying contract, not include a financial institution, then you've got to ask yourself how you're going to frame your pleas for relief to apply to a bank that's not part of the underlying contract with you and your opposite number. So before courts in litigation world, you join the bank as a second defendant or whatever, but that's not available to you in arbitration unless you have made the application to join a non-signatory. Failing which, you've got to think very carefully how you frame that call for relief in any event.
I think over in Malaysia, we do this, we face this situation quite often, and one of the reliefs that we ask for is to prevent the party from receiving the money. Yeah. So once that is out, then that's fine. The third party applications going to court can come later.
Here in Malaysia, to restrain the bank from paying, you need to prove fraud on the face of the bond itself. So that's almost impossible. But we are rather liberal on either restraining the party from making the demand or receiving the money, which then freezes the money until the later. So that's still possible from an emergency arbitrator. Use your mic.
There's an event going on, ASEAN Sports or Olympics, and there's a problem. A decision has to be made in about 12 hours. Whether this particular person has been tested positive for drugs and whether the test is proper, or there was once a problem, I think about 10 years ago, Grand Prix. They were having it in Singapore and they wanted to prevent a particular person from competing as 3 hours they had to decide, 4 hours. So emergency arbitration is a good thing.
The thing is this, if you're an emergency arbitration using institutional
You leave lawyers
rules,
to talk, this is what happens.
I think a lot depends on the institution. SIAC is, I'm a Malaysian. I was appointed by the SIAC, and they breathe down your neck all the time, right? So things move very quickly. If they don't, you will get a call, Sometimes 3 calls in a day. So it works. It works.
It's already 6:39, 6:40, and we've got 20 minutes to rush across to Majestic for those who are attending the dinner. So thank you everyone for your participation. I hope it has been useful. And I again thank my fellow friends, old friends and one new friend for the debate that has taken place. Thank you very much.
Thank you to our panel and our excellent moderator for that very intense rapid-fire debate session. We hope you enjoyed the session as much as we did. May we kindly request the debaters and moderator to remain on stage, and we'd like to invite Danish Chandran, Assistant Director of the AIAC, to come up on stage and present a token of appreciation to our speakers and moderator. Thank you. With that, distinguished guests, ladies and gentlemen, we've come to the end of our first day of our ADR week. We hope the event today not only gave you a deeper understanding of the new trends and challenges in international arbitral practice, but also a better understanding on international arbitration as one of the effective mechanisms of ADR to resolve commercial disputes across different sectors and industries. We're eager to meet you all once again tomorrow morning with breakfast provided for the second day of our Asia ADR Week 2023 at 8:30 a.m. tomorrow at the dining area located on the lower ground floor. The first session will commence at 9:30 a.m. Without taking much more of your time, may I invite you all to join us for the gala dinner at the Grand Ballroom at the Majestic Hotel right across the road at 7 p.m. Thank you.